Have you been dismissed from your job and wondering if it was fair? In this video, I'll break down unfair dismissal in simple terms, your rights, time limits, qualifying service, and what employers must prove. Let's start with what unfair dismissal means. Unfair dismissal happens when an employee is dismissed without a fair reason, or the process followed is not reasonable. There are 5 potentially fair reasons an employer can dismiss someone. 1. Conduct, meaning the employee has undergone a misconduct or gross misconduct, for example, breaking company rules. 2. Capability, such as an employee lacks skills or qualification to perform certain job. 3. Redundancy, when a certain job role is no longer needed. 4. Statutory illegality, meaning continuing employment would break the law, for example, when the employee's right to work expires. 5. Some other substantial reason, for example, business reorganization or refusal to accept reasonable changes to terms and conditions. Even if there is a fair reason, a dismissal can still be unfair if there is no fair process followed, such as skipping investigations or hearings. The decision to dismiss is unreasonable under the circumstances, such as, has the employer treated similar cases the same way? Or did the employer consider other options before dismissing, for example, giving an extra training, a warning, or a transfer instead? In short, both the reason and the way it's handled matter when deciding if a dismissal is fair. Let's see what counts as dismissal. Leaving aside the universal requirement of acquiring the early conciliation certificate, the claimant must also satisfy the conditions mentioned below. 1. The claimant was employed by the respondent under a contract of employment. 2. That the claimant was dismissed as defined. A. Employer ends the contract. If your employer ends your job contract, whether they give you notice, or they end it immediately without notice, this counts as dismissal. B. Fixed-term contract, not renewed. If you are on a fixed-term contract, for example a 1-year contract, and it reaches the end date, and the employer does not renew it, that is also treated as dismissal. C. You resign because of the employer. If you resign because your employer seriously breached the contract, or they treated you so badly that you had no real choice but to leave, the law treats this as dismissal too. This is called constructive dismissal. 3. In most cases the claimant was employed for the necessary qualifying period. The employer may sometimes argue that a claim cannot be brought because the employee did not work for the qualifying period under a lawful contract. Who can bring a claim? Can everyone bring a claim? No. To bring a claim, you must legally be an employee, usually have 2 years of service, and obtain an ACUS early conciliation certificate. Now let's look at automatically unfair dismissal, which is treated more seriously in employment law. In these cases, employees do not need any qualifying service. This means if the main reason for the dismissal is one of these protected grounds, the dismissal will almost always be unfair, regardless of the process followed. Common examples include dismissal related to pregnancy or maternity, dismissal for whistleblowing, where an employee raises a protected disclosure, dismissal for taking part in trade union activities. Is there a time limit to bring the claim? Yes. An employee normally has 3 months less 1 day from the date their employment ends to submit an employment tribunal claim. However, this time limit can be extended if employee can show there was a genuine reason why it wasn't reasonably practicable to submit the claim in time. For example, if they were seriously ill. In those situations, the claim must still be made as soon as reasonably possible afterwards. For discrimination cases, the tribunal has greater flexibility. The time limit can be extended where it is considered just and equitable to do so. So while the 3-month deadline is the general rule, there are limited circumstances where an extension may be allowed. Let's talk about the effective date of dismissal, or EDT, because this one date is crucial in unfair dismissal claims. The EDT is the date the dismissal actually takes effect. And why does this matter? Because it decides 2 key things. First, whether the employee has enough service to bring an unfair dismissal claim. And second, when the 3 months less 1 day tribunal time limit starts ticking. So getting this date wrong can completely change the outcome of a case. Now, when does a dismissal actually take effect? It's simple. A dismissal is effective when the employee is told about it, or when they've had a reasonable opportunity to find out about it. And here's an important point. An employee can't delay the time limit by ignoring the letter or refusing to read the email. The tribunal will still treat the dismissal as having taken effect when they had the chance to know about it. So remember, it's not just about the decision to dismiss, it's about the exact date it becomes effective. Now let's look at how the method of communication can affect the effective date of dismissal, the EDT. If the dismissal is communicated in a meeting or over the phone, the EDT is usually that same day, because the employee is told directly. If the dismissal is sent by letter or email, the key date is not when it was sent or delivered, it's when the employee actually reads it. But what if the employee deliberately avoids opening the email or the letter? In that case, they can't delay the legal effect. So the EDT will be the date when they first had a reasonable opportunity to read it, whether they chose to or not. And finally, if the message is passed through a solicitor or another third party, the EDT will be when the employee is informed by that person. So the EDT is all about when the employee knows, or should reasonably have known, that they were dismissed. If the tribunal decides the dismissal was unfair, it doesn't just say the employer was wrong, it can also award a remedy. The first option is reinstatement. This means you get your original job back, with the same pay, same benefits, and your continuity of service is protected as if you were never dismissed. The second option is re-engagement. This is slightly different. You return to the organization, but in a similar or comparable role, not necessarily your old job. Now in reality, these two remedies are quite rare, because they require a workable relationship between the employer and the employee. The most common outcome is compensation. Compensation is made up of two main parts. First one, basic award. This is calculated using your age, length of service, and weekly pay, very similar to a redundancy payment. Second one is compensatory award. This covers your actual financial losses. For example, loss of salary, loss of benefits, loss of pension, and the time it may take you to find a new job. But remember, you must try to reduce your losses by looking for another job. Otherwise your compensation can be reduced. Thanks so much for watching. If you found this video helpful, don't forget to like, share, and subscribe to the channel. I'll be back soon with another video. Until then, bye from HR with Pooja.